Thank you for taking a few minutes to learn about the Kansas Commercial Industrial Hemp Program. The program is administered through the Plant Protection and Weed Control Program within the Kansas Department of Agriculture. KDA is implementing the Commercial Industrial Hemp Program as authorized by the 2018 Farm Bill and the Commercial Industrial Hemp Act. Beginning January 8, 2021, KDA will accept applications for individuals looking to cultivate or produce industrial hemp as producers, otherwise known as growers, on a commercial scale. Let's take a look at the regulations associated with the Commercial Industrial Hemp Program. They are K.A.R. 4-3422 through K.A.R. 4-3430. We'll look at licenses required, planting and pre-harvest requirements, sampling, testing, and harvest requirements, effective disposal and violations, transportations of industrial hemp, planting restrictions, signage requirements and volunteer plants, access to records and property, negligent violations and corrective action plans, and state educational institutions. Our first regulation clarifies that K.A.R. 4-3422 through 4-3430 apply to the commercial production of industrial hemp and not to the production of industrial hemp for research purposes. It also sets out the general requirements for commercial industrial hemp applications and licenses and requirements for certain information that licensees must report directly to the USDA Farm Service Agency. This regulation states that each licensee will be held responsible for any hemp plant cultivated or produced in violation of the Act, whether done by the licensee or by an employee, agent, contractor, or volunteer of the licensee. It also provides criminal history record check requirements and provides for the modifications of a license and provides that licenses are non-transferable except in the event of the death of the licensee. K.A.R. 4-3423 sets out planting and harvesting requirements. It requires that all industrial hemp cultivated or produced for commercial purposes originate from authorized seed or clone plants and states that all hemp seed shall be considered agricultural seed pursuant to K.S.A. 1415 and amendments thereto. It requires licensees to submit a field planting report within 15 days of planting and requires licensees to maintain documentation regarding the source of all industrial hemp cultivated and produced, as well as documentation regarding the disposition of all industrial hemp cultivated or produced. Our next regulation establishes the requirements for the testing and sampling of industrial hemp, including sampling and testing fees. It requires all industrial hemp be sampled no more than 15 days before harvest and prohibits licensees from harvesting until they have received approval to do so. It also establishes permissible levels of delta-9 THC of industrial hemp plants and sets out the requirements for effective disposal in the event that the THC content is found to be greater than 0.3% on a dry weight basis. This regulation provides that each licensee issued an order to effectively dispose of plants shall be placed on a corrective action plan if the violation is deemed negligent and reported to the Kansas Attorney General's office if the violation is the result of a culpable mental state greater than negligent. This regulation establishes that all plants or plant parts deemed to have been cultivated or produced in violation of the Act for reasons other than containing a THC concentration greater than 0.3% on a dry weight basis may be subject to effective disposal and sets out the requirements governing effective disposal. This regulation provides that all licensees who are required to dispose of or destroy plants must do so in compliance with the Controlled Substances Act and the requirements of the United States Drug Enforcement Agency. This regulation provides that a licensee who is required to destroy industrial hemp shall do so at their own expense within 10 days of receiving notice that destruction is required. It also requires reporting the number of acres effectively disposed of to the department. This regulation also provides that a licensee who violates the Act with a culpable mental state of negligence shall be placed on a corrective action plan, and a licensee who does so with a culpable mental state greater than negligence shall be reported to the Kansas Attorney General's office. As we take a look at K.A.R. 4-34-26, this regulation establishes requirements for the transportation of industrial hemp. It requires all industrial hemp that is transferred to be accompanied by a bill of lading and a certificate of analysis or other documentation if available. It also provides that anyone in possession of unprocessed industrial hemp without a valid hemp producer's license or a bill of lading may be presumed to have cultivated or produced that industrial hemp in violation of the Act, and requires that all licensees comply with all provisions of the Act and the implementing rules and regulations, as well as all applicable local, state, and federal laws and regulations related to industrial hemp. The next regulation establishes additional restrictions on hemp producers, including where industrial hemp can be cultivated or produced. It also prohibits interplanting, except by a state educational institution licensees, and with the exception of ground cover. This regulation also includes requirements that signage shall be posted at each licensed growing area. It establishes that licensees shall allow the Secretary to inspect unlicensed growing areas and adjacent areas, and requires that each licensee destroy volunteer plants for at least 3 years after the last date of planting. Our next regulation deals with access by the Secretary to records and property of licensees. It states that the Secretary shall be allowed to inspect all records of licensees related to industrial hemp and access all land of licensees that has been identified for the production or cultivation of industrial hemp to ensure compliance with the Act. It also provides that each licensee shall consent to the Secretary providing information to the USDA, law enforcement, fire and rescue agencies, and the public regarding each licensed growing area, and that each licensed growing area and adjacent areas shall be subject to access and inspection, including sampling, by the Secretary at all reasonable times. As we look at K.A.R. 4-34-29, this regulation deals with negligent violation and corrective action plans. It sets out a non-exhaustive list of events which may constitute a negligent violation, and provides that a licensee who negligently violates the Act shall be required to follow a corrective action plan developed by the Secretary for a minimum of 2 years, and sets out different requirements for corrective action plans and disciplinary actions based on whether the licensee has committed a first negligent violation, a second negligent violation within 5 years of the previous negligent violation, or a third negligent violation within 5 years of the first negligent violation. The next regulation establishes requirements for state educational institution licensees and state educational institution hemp processor registrants. It provides that state educational institutions are exempt from application and licensing or registration fees, but shall be subject to all other rules and regulations applicable to licensees. It requires each state educational institution seeking licensure designate an individual who shall be responsible for all hemp-related activities, and allows a state educational institution licensee to be granted a multi-year license upon written request. Let's take a look at the changes between the research and the commercial program. For a grower's license, for the research program, a license was required for all individuals participating. For the commercial program, the license is required for the primary individual on the producer license. The primary individual is responsible for employees, agents, or volunteers of the license. A distributor license was required for the research program. No license is required now for the commercial program. However, individuals must comply with K.A.R. 4-34-26 regarding the transportation of industrial hemp. and K.S.A. 2-3908. We'll talk about unlawful hemp products, penalties, and exceptions. A processor license was required for the research program, and now for the licensing for the commercial program, the structure will be determined by the state fire marshal's regulations. For a state educational institution, for the research program, a license was required for all individual participating. Licenses required for primary individual on the producer license now for the commercial program, and the primary individual is responsible for employees, agents, or volunteers of the license. Let's take a look at the key differences between the commercial and research programs. For license type, for the research program, there were growers, distributors, processors, and state educational institutions. Now with the commercial program, producers and state educational institutions are licensed, and they will be known as growers. The background check for the research program had all individuals participating required. Now, for the commercial program, only the primary individual. A background check fee of $47 is still required. The commercial program application fee is $100. The license fee is $1,200. Planting reports are still required, as are pre-harvest reports. Voluntary destruction reports are required if applicable. Harvest reports are also required. Production, distribution, and processing reports are no longer required for the commercial program, and the research reports are no longer required. Taking a look at the state and national criminal history record check, only the individual applying for a license must submit for the required fingerprint-based state and national criminal history record check no more than 30 days prior to the license application being submitted to KDA. The required fingerprint card must be submitted by KDA to the Kansas Bureau of Investigation. All required fingerprint-based state and national criminal history record checks completed by the KBI must be received and reviewed by KDA for licensing consideration. Once licensed, the licensee is responsible for all employees, agents, or volunteers and their compliance with the Act. Let's take a look at reporting requirements and deadlines. License application for each individual seeking a license to grow or cultivate industrial hemp are due to KDA by March 15 of each year. With respect to reports, the planting report is due to KDA no more than 15 days after each planting. As a reminder, growers must also report their acreage to the USDA FSA. If you are unfamiliar with the USDA FSA, please consult your county FSA office. Pre-harvest reports are due no fewer than 30 days prior to each intended harvest. Voluntary destruction reports are due no fewer than 15 days prior to each intended destruction date. A harvest report would be due to the agency no more than 10 days after each harvest, and license expiration. Grower's license will now expire on December 31 of each license year. As previously mentioned, in addition to filing a planting report with KDA, hemp acreage must be filed with USDA FSA. Please consult your local FSA office for specific information. If you are not already registered with the FSA, please contact your local FSA office to get registered. Producers must provide KDA a list of all areas planted with hemp, which FSA has on file. The following table shows the important fee types, program fees, and fee due dates. The criminal history record check fee of $47 is due at the time the commercial hemp producer license application is submitted. At that time, an application fee of $100 is also required. This fee does not apply to the license fee. The license fee of $1,200 would be due within 15 days of conditional approval of the license application. Testing fees of $225 per laboratory test, as each lot must be sampled separately, and this fee would be due upon the licensee's receipt of the invoice provided by KDA. Subsequent sampling fees. Include transportation and inspection time of $45 per hour and mileage at the rate established by the Kansas Department of Administration. This would be due upon the licensee's receipt of the invoices provided by KDA. A modification fee of $50 for each requested change to a license previously issued by the department, and this fee is due at the time of the request for modification of the license. KDA will begin accepting 2021 industrial hemp producer license applications on January 8, 2021. More information on the KDA's commercial industrial hemp program can be found on the website agriculture.ks.gov/industrial hemp. Please note that KDA can answer questions but will not provide direct assistance in completing the commercial industrial hemp producer license application.